Welcome to the LivXplore Podcast. If you like what you hear, please hit like and subscribe. Welcome, everyone. I'm Sean Payne of LivXplore, and I have my co-host with me today.
I'm Isaiah Chass.
And we have another great podcast for you today. We have Pauline Deixler of the law offices of Pauline Deixler, located in downtown Petaluma.
Hi.
Thank you very much for joining us today.
We're happy to.
So you are just down on 6th Street in that cool old Victorian on the river there.
That's right. Yeah, 6C Street, right at the turning basin.
Right. And how long have you been there for?
I have been there for 8 years.
8 years.
Yeah, maybe, 8 years.
Yeah, so for our listeners, if you're in the turning basin, it's one of those cool Victorians that line the turning basin down there. That's very accessible that way. So
Love it. Yeah, no, we have a great office down there. I'm just going to turn my phone.
Oh, sure. Yep.
Beeps. Yeah, I love it there. We have great accessible offices, so I can see clients. My offices are upstairs, but I have an office downstairs if necessary, conference room for full accessibility.
Very cool.
Yeah.
And we were talking about this a little bit before we hit record, that you're pretty much local that way, that you're from.
Yeah, I'm from Point Reyes, which is close.
Very close.
Yeah. And when you grow up in Point Reyes, Petaluma is the town that you come to for anything that you need besides, the small things you can get in a small town. So, so I feel like a local. I feel like, I'm as close to a local Petaluma as can be.
Mm-hmm. Do you, you started your practice here 8 years ago, or were you here before that?
No, so I, after law school, which was now 21 years ago, I practiced in the city for a while. I practiced in the East Bay. Then spent many years in Emeryville. So, various places in the, Bay Area. But I moved here to Petaluma about 15 years ago and opened my practice about, 8 years ago after having my second daughter.
Oh, very cool.
Yeah.
Very cool.
And did you always specialize in real estate law? Was that something that out of law school you knew you want to focus on?
No, not necessarily. Well, I did always focus on real estate and business, but it just kind of happened that way. I didn't really know that I was going to focus on it. I had thoughts of being an entertainment lawyer at some point, but didn't want to move to Los Angeles or New York. So,
did you do any dabble a little bit like that, or
not really? I mean, you really, unless you're in a couple of very specific firms, you really have to
immerse yourself.
Yeah,
you're right.
Get into that that practice area. And I met with some attorneys. I tried, but it never really panned out. And so then, I mean, entertainment law really is business law. It's very close to business law. So, that's kind of how I got started with business law, and then real estate's kind of just a natural progression.
Nice. And within the real estate, where are some of the specialties that you focus on? Landlord-tenant law.
Yeah. I do specialize in landlord-tenant law. I would say that in the last 5 years, landlord-tenant law has become very much more complex than it has been before. Certainly a lot of changing rules locally, statewide. So landlord-tenant has really kind of kept me busy in the last, 5 years.
Mm-hmm.
And I would say that in general, I represent landlords, but I do represent tenants as well. It all depends on kind of who comes through the door. In general, I would say landlords make up the bulk of my practice, but I do have commercial tenants and residential tenants that I do represent. And I do represent commercial. I do work in commercial real estate as well as residential real estate.
Okay.
And again, getting back to the complexity of landlord-tenant laws as of late, the rules are very different, whether you're dealing with a residential tenant or a commercial tenant.
Right.
That's another thing that I'm sure we'll get into that at some point today. But that's another something to be aware of is what type of tenant you're.
Sure. Can you tell us a little bit like about your experience dealing with landlord-tenant issues across various counties in California? How's that shaped your approach to these type of disputes that way?
Right. Well, so in the last few years, and before that, in other areas. So since 2019, we've had the Tenant Protection Act, which is a statewide rent and eviction control act. Before that passed, some counties and or cities had not versions of the act, but their own just cause for eviction and rent control acts. There's two prongs to rent and eviction control. One is rent control, limiting the amount of rent increases that can be made in any particular unit, in units that qualify for the ordinance. The second is just cause for eviction, which is a requirement that if you're ending a tenancy, that you have a just cause. And there are a number of just causes, non-payment of rent, nuisance. There are a number of just causes that are for fault causes like non-payment of rent, nuisance, illegal activity. Then there are other just causes that are not, they're called no-fault just causes, which are owner move-in, taking the unit off the rental market. So and these are all, again, going back to the just causes for eviction. Recently, in 2019, the state passed a just cause and rent control ordinance. That, depending upon where a client lives or where a client owns the property in question, that may apply. If you own a property in Petaluma, however, the state law wouldn't apply, the local law would apply.
Yeah.
And the question, so the first question you deal with when you're dealing with a tenancy and a potential eviction is, where are you and what ordinance applies? So we could have the state ordinance applying. We could, if we're in Petaluma, in the city limits of Petaluma, we could have the city ordinance applying. So it really depends on where the property is located, whether there will be an ordinance applying or not. And that can really shape how an owner will use the property, right? If the owner has tenants and the owner wants to sell the property, but the property is subject to the just cause Petaluma ordinance, the owner would need a just cause in order to remove the tenant to be able to sell the property. And there's only 7 just causes, you know what I mean? So
and most of those are curable as well, correct?
Some of them are, yeah. So the at-fault just causes are potentially curable. Non-payment of rent is a curable cause. You issue a notice, and tenant has the opportunity to cure it by paying. Right. There are other illegal activity potentially is curable. Some illegal activity is too illegal that it's deemed not curable. So
Can I just kind of curious for like the landlords out there, what would be seen as like curable that way?
So right. That's a good question. There are certain breaches of the lease that would be deemed, the lease or rental agreement that you have with this tenant, that would be deemed not curable. Subletting without permission or removing the subletter on demand.
Okay.
But if they did,
yes. But subletting could be a breach that is non-curable, meaning if you give a warning to the tenant, at that point, even if they were to cure, it would still be considered a breach so significant that you could evict based on it. Now, I tend to focus on eviction, but there's many steps before eviction that happens when you're dealing with a property and a tenant in possession. There's many other ways to deal with needing the property emptied, and there's often we come to agreements with tenants, cash for keys type arrangement where we'll offer something to the tenant in order to get them to agree to vacate. So there's many steps before an eviction. I do litigation, and so I tend to focus on, when I'm discussing litigation, getting to the eviction, but there's many steps before that obviously the owner and in conjunction with myself, we try to employ before we get to the last step of filing an eviction.
Sure. You kind of touched on a little topic that I think is really important for the real estate industry. So let's say someone's been renting out a property and then they decide to sell it. What would be the appropriate course of action to make that happen?
Right. Well, it totally depends on where you are. Yeah.
So let's say we're in Petaluma, just for the
right.
sake of that.
So, right. If you're in Petaluma and the Petaluma ordinance also only applies for people that own 3 or more properties.
Right.
Okay, so if you're in Petaluma and you own 3 or more properties, and
that could include your primary residence, correct?
It could, yeah. So it has to be owned by the same owner. So meaning, if one property is owned by you in a trust and one property is owned by you as an individual, that's not the same. Okay, so
the trust.
Yeah. Well, so it all depends on what the deed says, right? If you own it as trustee of a trust, that's not owning it as an individual. That's not the same person for purposes of the count, right? So and the Petaluma ordinance is new,
right,
and hasn't
been challenged quite yet.
Yeah, to my knowledge, it hasn't been challenged yet. And if it has, there's no published decisions on it. So we really don't know how this is all going to play out potentially. My experience with other eviction control ordinances and other rent control ordinances in other jurisdictions is how I kind of formulate my thoughts on what would happen, if any part of the ordinance is challenged. But getting back to your question, so your question was, if you own a property in Petaluma,
yep,
and you're subject to the ordinance,
yes, and
you want to sell, but there's a tenant in there, what would you do?
Yes,
that's a tough question because there is not I want to sell the property, so that's not one of the just causes under the Petaluma ordinance. There's options for owner move-in. However, if you do an owner move-in, the owner has to move in for a certain amount of time. There's an option for a voluntary agreement with the tenant to vacate.
Right.
Yeah, cash for keys. That is really what
a lot of people
would
getting to
employ.
Sure.
Yeah. Because there is no one of the just causes is not I own it and I want to sell it.
Right.
Which can be problematic. There is a just cause for remodeling and for doing remodeling, extensive remodeling. So potentially that could be a just cause that you could use if you want to do a good amount of work. Not just cosmetic work, but work that would cause the tenant to have to leave for more than 30 days. That's an option. But really in that situation, if the Petaluma ordinance applied, you would want to look into a cash for keys type of agreement with tenant. The Petaluma ordinance also requires for the just causes, the no-fault just causes like owner move-in, remodeling, that a relocation fee be paid to the tenant as well. So in considering a cash for keys, you can kind of look at the ordinance and look what that fee would be, and that can kind of not always guarantee certainly what the tenant would agree to, but give you a figure to keep in mind. It all really depends on the tenant and what you can negotiate.
Not the state level. Say you're in Santa Rosa, isn't there a no fault just cause for selling? However, then the next owner would potentially have to give them the right to move.
So there is in the state, in the Tenant Protection Ordinance of 2019, there is 2 ways that you can do a sale, that you can remove a tenant. The first one is if you're under contract, you have a contract to sell, and you've given the tenant notice, and then the new buyer has to agree to, I think, live in the property for a year. So that, yeah, right, for the future buyer. I believe you have to be, in that case, in escrow or under an agreement to sell. So that is an option there. That's not in the Petaluma ordinance. And interestingly enough, so which ordinance applies? If you're in Petaluma and the Petaluma ordinance applies, that means the state ordinance doesn't apply. So even if for some reason you don't fall under the Petaluma ordinance, you don't then default to the state, you just use the Petaluma.
And does the local ordinance always have to be stricter?
So, right, the question of applicability of the ordinance is if there's a local stricter ordinance, then the state ordinance doesn't apply. So it's a determination that's made as a whole. You know what I mean? That is the ordinance, because frankly, a local ordinance may be more lenient in one small area, but as long as it's deemed stricter as a whole, then it will apply. And the state ordinance does not apply. So people had thought at one point that, you do the local ordinance, then fall back to the state ordinance if you don't apply if the local ordinance doesn't cover your situation. But that's not, you stick with the local ordinance. If you're exempt from the local ordinance, then you're exempt, period. You don't then default to the ordinance.
Okay.
Yeah. So a little complicated, but one ordinance applies, period.
Right.
You don't then apply another ordinance if you're exempt, because there's exemptions, many exemptions that people sometimes do want to use for a local ordinance. And some have argued that potentially if you're exempt from one ordinance, then the other ordinance would apply. But that the courts have found that that's not the case.
Okay.
So it's the local ordinance, period. That makes
So, like, long story short, call Pauline. like that's very confusing.
It is super confusing. I mean, I would say that especially since COVID, which is now thankfully over, from a law immediately changing eviction moratorium type position. It's, we're not dealing with COVID, thank goodness, on a significant level as we were a couple of years back. That really changed the whole landscape for landlord-tenant law in a big way for the time during the eviction moratorium and all that. But it's complicated.
Yeah.
It really is. It's you have to, for each property, you have to look at where you are and then what applies, and make your decisions based on that. And you can be in Petaluma, but outside of city limits, then the local ordinance wouldn't apply.
Right.
It would be the state ordinance. So,
what's the most common call from a landlord that you get, whether it be for non-performance by a tenant, a unit that is so severely below market that that
Yeah.
the rent increase won't get them up or for sale?
Yeah, I would say that it depends. At times, non-payment is my most common call. I think people are having a hard time navigating the ordinances that I was just kind of touched on, and I'm sorry if it was a bit confusing. You kind of need a chart to figure out.
Yes.
Yeah, and I have one of those flow charts that I provide for clients because there are lots of options, right? Or there's lots of potential paths depending on where you are and what you need to do. But I would say at times non-payment is the big issue. Now it seems to be people wanting to leave the area and sell their rental properties and don't want to sell them with tenants in them. Right. So they need a way to get the properties vacant before selling. And I don't want it to seem like all I do is evictions. I do a lot. I do a lot more.
Can I jump back?
Yeah,
because I just think there's an important, especially for our industry.
Yeah.
And I know again, like every ordinance and jurisdiction is different a little bit. But is there a scenario that potentially someone could, whether they come to an agreement or the tenant has vacated the property, and then the seller sells the property, and then the new buyer has the intention of renting the property and turning it back out into a rental? Are there any potential situations where that new owner needs to go back to the previous tenant and offer them residency at that point?
So,
and the only reason why I bring this up is just for sellers and listing agents,
right?
Maybe just make sure you're disclosing it it was a rental property, and for them to do the investigation on this. And
yeah, yeah, absolutely. I don't. I'm trying to think. There is a situation where you get you terminate a tenancy for a remodeling. And there is a caveat in that, and this is the state law, so it has to be a jurisdiction where the state law applies. There's a caveat that says if you terminate a tenancy to do remodeling and you present the permits as your to do in the termination notice, and they leave, that if that remodeling doesn't commence, that you have to offer the unit back to them on the same terms that it was rented to them. So potentially, if there's a sale in between when the tenancy is terminated for remodeling and then the remodeling doesn't commence, I think it potentially that, and there's a sale at that moment, potentially the new owner would step into the shoes of the old owner and have to offer that. But I'm not sure that
it's a likely.
Yeah, I'm not sure that scenario.
And I actually understand that protection because that way you can't evict them, and so then you turn around and say, "Yeah, exactly." Yeah, so I'm kind of understand. I just wanted to make sure that from our end that we were properly disclosing everything when selling a home, so that it doesn't come back and come after a seller in any.
So I mean, that does bring up the situation where if we're under the state law, you've sold. If we're under the state law and you've promised that the owner was going to move in, that scenario we just discussed a little while ago, where you terminated based on selling the property, and but the new owner has to occupy the property for a year. So in that case, there is an obligation on the buyer,
right?
But they will be aware of that in the purchase. You know what I mean? At least I would hope that would be made clear that the new owner is required to occupy the property for a certain amount of time. This may have never come up because there's other reasons to terminate that potentially were used. But if that's the case, it would be a part of the agreement, and it would be made very clear to the buyer their obligations post close.
Yeah, I bring this up just because I think potentially we may see this scenario happen where it's not properly disclosed. I don't know what's on listing agents' radar right now. That's why I just bring it up. Hopefully our industry is like, oh, wait a second, light bulb. I need to let potential buyers know that this was a rental, or something of that nature.
Yeah. So I think that it would definitely be on the seller to notify buyer of any post-sale obligations. You know what I mean?
Right.
And hopefully it would be a subject of discussion. But as we know, sometimes sales happen and disclosures don't happen in full. So, that does happen, I would imagine, and that could happen in this scenario as well. Hopefully it would have been discussed with all parties.
Right.
Yeah.
It's really interesting how much it affects values in California.
Yeah.
I had a friend that was looking to purchase out of state multifamily,
Mm-hmm.
and I forget what state it was, but they don't have any tenant protection acts of any kind.
Mm-hmm.
So a future owner could immediately on day one evict those tenants. So even though the rents were probably 30 to 40% of market value, it doesn't really matter for a future buyer because on day one they can evict them and get up to market. But in California, it really affects the value of the rental property.
Marketability, absolutely.
Yeah, I mean, if you have gross rents that are 40% of market rents, that hugely affects the value.
It does. You wouldn't think that in a rental property a tenant would be a reason not to buy, right? But the tenant that you can't raise the rent any more than a certain amount per year, or a tenant that potentially you couldn't get rid of, is problematic to a buyer that wants to buy even a rental property.
Right.
So it, as we all know, it can affect the amount of money that you can get for a property. And that being said, there are great tenants, of course, that many rental properties are sold with the existing tenants in place. But the buyer is somewhat stepping into the shoes of the seller as far as what's gone on with the tenancy and taking over the obligation to, do everything legally from the you become the buyer. So you become the owner rather. So you want to make sure that what you're buying, there's a good history and that you're not buying into problems that are going to come to haunt you after the close.
Yeah.
Something to think about. Of course, tenants, great tenants are in buildings that are sold every day.
Sure.
And, but it's definitely something to be aware of, that you're not only, the liability should change from the seller to the buyer once escrow closes, but we know that there are issues with tenants that can linger past the close and certainly come up at least for the new buyer. It's something to be aware of when you're buying, certainly, and do an analysis of where you are and what rules would apply. Sir,
ask questions.
Yeah,
ask these questions.
Yeah,
cool. In your experience, is it typically the best? I know we've focused a lot on the landlord and that process.
Yeah.
But it sounds like a lot of cases it's best to first approach it with a cash for keys option, a mutually agreeable resolution, as opposed to a potential eviction process.
Absolutely. The eviction process takes a minimum of 6 weeks from the end of the notice period. So if you're giving a 60-day notice, it's 6 weeks minimum. Again, this is a minimum.
Could we go through a mock, say someone paying rent, what would first step be, like you mentioned, 6 weeks?
So a non-payment of rent, you would generally do a 3-day notice to pay your rent or quit. At the end of that 3 days, if they don't pay or quit, and quit means leave. So if they don't pay or quit, then you can file the eviction lawsuit. And it's a lawsuit that you file. It's a short it's on a quicker calendar than other civil lawsuits that you file, and you may see trial in 2 years. It goes much quicker than that. Nonetheless, it takes a minimum of 6 weeks, and the actual length will depend upon whether the tenant is represented or whether they have tools in their tool belt to fight the eviction. But if you're doing a non-payment eviction, you're looking at the 3 days, then filing the lawsuit. You have to have them served. I use a process server, and there's details on why I think it's recommended that you use a process server for service. But then the tenant, once they're served, has the opportunity to answer. We're now about 3 weeks in if everything's going right. If tenant doesn't answer, we can get a default judgment in about 3 weeks, and the sheriff can come out to evict in about 2 weeks after that. So that's this kind of 6-week, if everything goes well, timeline.
Okay. And then after a 60-day notice?
That's after that's after a 3-day notice or a 30-day notice or a 60-day notice, depending on what scenario you're in. So that's kind of a really quick, broad overview of the default eviction if tenant doesn't answer. If tenant answers the lawsuit, then there's a trial date scheduled. And so there's some delay in that. There can be various motions that can be filed by a tenant. This is when the pitfalls of landlord-tenant law can come up. Because if on the, say, 5th week you're going to trial with this tenant, and the tenant notices that you spelled the name wrong on the 3-day notice, you have to start all the way back. If the notice is incorrect, then everything based on that notice is going to be thrown out, and you have to go back, do a new notice, and start all over.
What if the lease agreement, this might be crazy, but what if the lease agreement was spelled incorrectly?
Well,
you didn't know.
I actually have the scenario exactly like that happening right now. The property management company had accepted a tenant. The tenant had applied in their name, of course. There was a transcription error, so the property management company had transposed 2 letters in the tenant's name. So the lease and all the tenant communications were with the tenant with the name spelled incorrectly. When I get a case, I look at the lease and use the name on the lease. So that happened. Then the tenant's defense was, my name's spelled incorrect.
Yeah.
So the good thing is we were at a point where we came to a settlement agreement with that tenant. It's actually supposed to be signed tomorrow, so hoping it gets signed. But, you have to be absolutely careful. I actually checked with this property management company about the spelling of the name, and they confirmed that's what they had. And that's what they did have in their records. There was an early error, and granted, the tenant didn't mention anything. The lease was incorrect. Everything had been incorrect for years. But that's the kind of thing that can that torpedo a case. There were other factors that led the tenant to want to settle the case, in my opinion, that helped us out there. But if those factors hadn't have been there, we would have had to start all over again. Yeah. So, and that happens all the time because it's a fast process, because the eviction process is faster than other civil processes. The judges are required to make sure everything is done absolutely perfect. If any error like that can get the case thrown out, even if you've gone through 18 months, to get to the point. Yeah.
So always get someone's ID when you're signing a lease.
Always get someone's ID. Double check the spelling. Yeah. It's crucial. And on 3-day notices, there's very specific rules as far as what can be included on a 3-day notice to pay a rent or quit. There's very specific language that has to be included on all these notices that isn't intuitive. You wouldn't think this language has to be there. It's required by statute. It's about, for one example, there's language about reclaiming property that's left that has to be included on every notice, regardless of if it's a notice about reclaiming property or paying rent. So it's a good idea unless you're really versed in drafting notices and terminating tenancies and all that you consult with attorney, at least do some research into drafting notices correctly, because I've seen it happen where a self-represented party will get to the point where I'm in trial on another case, and you see people there, and you can see how long they've been working to try to get to this point, and the judges really have no choice but to throw them out.
But yeah, them doing their own stuff, pulling documents off of a web.
Right, exactly. And especially with the COVID change, I mean, the amount of kind of incorrect information that's out on the web, as far as, documents that may have been correct, 2 years ago, they're just not correct now because things have changed. Those rules no longer apply. Landlord-tenant I never thought it would become such a dynamic field where things are changing all the time, but it has become that. Thankfully, it's slowed down a little bit, and it seems like we're to the point where we're not going to have new laws and rules passed every 6 months. But the information on the internet is some is correct, some is totally outdated. Right. So be careful when approaching it from that. It's easy to think that you have the right notices because you're looking on the internet and it seems like these are legitimate, but they could be not legitimate for the jurisdiction you're in. It really depends. Yeah.
What advice would you give to a property owner that's maybe just purchasing a property for the first time, a rental property, and I guess your advice for them to avoid potential disputes in the future?
Yeah. So, interestingly, just in July, a new law has passed regarding security deposits. I don't know if you guys have heard about this,
which is very, very confusing.
It's security deposits were kind of the last really secure thing that landlords had that they could get and that could, protect them a little bit. The amount of the security deposit is now, if you're not exempt, or if you are exempt, yeah. So if you're not exempt from the law, and there are certain exemptions, you can now only charge 1 month's security deposit. I think that for a new landlord, the best thing you can do is check out your potential tenants. It's amazing how many landlords don't call the last landlord or the landlord reference or any reference on the application.
Well, a lot of times eviction records won't even show up.
That's right.
You can find their eviction history, but you won't know.
Evictions, until they become judgments, are not visible to anyone. They're shielded. So unless and until an eviction actually goes through all the steps to the final step where there's a judgment issued, and there's many opportunities before that for the case to settle or things to happen, but unless it gets to that last point, there won't be a record of the eviction that you can find. Like any other case, you can look up on the county website. You won't find the eviction. So it's really important to get a thorough application, really look at the application, read it carefully, see what the history is like, see what, really do a close examination. for as much of a deposit that you're legally allowed to, and it really depends on the new law. There's exemptions there too to the security deposit law. Have a well-drafted lease. Certainly, there's certain requirements as far as disclosures. Everyone has to disclose about bed bugs, even if you've never had bed bugs or think you never had. There's addendums required that every tenant has to get that deals with bed bugs, that deals with lead if you're in a pre-1979 property. There's many things that you have to disclose to a tenant that if you don't, including the rent and eviction control applicable for your area, right? So if you're in Petaluma, it's a different disclosure than if you're in Santa Rosa, than if you're in Windsor. So having a well-drafted lease is crucial. Making sure you're doing all the required disclosures. And vetting a tenant as carefully as you can. There are some rules as far as what you can consider there as well. And that's a whole nother discussion. But source of income, you can't consider source of income. But, looking at your lease, looking at your tenant carefully, having a well-drafted lease, and then doing everything legally as a landlord. That's also a big part of it. I tell my landlords, you have to be the best landlord from this day forward, the best landlord you can be. And there's lots of rules you have to follow, and you got to follow them, or else you're asking for trouble potentially. So it's a big obligation to become a landlord in California. In the Bay Area, certainly there's a lot you have to know. There's a lot of rules you have to follow. So, understand that when putting yourself in that position. It's really not like the old days where you can just not comply with anything and you'll be all right,
Everything is good until it's not.
Everything's good until it's not. And people and tenants are informed today. They know their rights. And if they don't know them, they can easily find out what their rights are. So you're not going to get away with not doing the right thing. You know what I mean? So that's a lot, I realize, for landlords to take in. And it may make some people shy away from wanting to be landlords in this county, in this state. But that's what you got to do.
The security deposit thing alone, I think it's difficult because especially on a lower price property, say an $1,800, $2,000 a month property, a $2,000 security deposit won't even cover a new carpet if there's carpet stains. And I think in the past, a lot of property owners might accept a lower qualified tenant knowing that they could have a little bit higher.
They have a little bit of protection.
And now I think it increases that qualification standard. I think the law probably came into place to open up the housing stock.
Right.
I think it did the exact opposite.
Well, there can be opposite effects of each well-intentioned law does have opposite effects that do come up. The security deposit law, yes, I think was intended to open up rental properties, to people that don't have big chunks of money to put down big deposits. But I think it will have that effect of landlords are going to be much more careful and much more, they'll have different requirements, So each law definitely has unintended consequences that I deal with a lot of. There are things that just have come up because the law is what it is, and we're all just trying to live in this world, and problems arise, right? But it can be frustrating, at least initially, until people get used to it. After a while, it'll calm down, and people will figure out how to navigate. But it can be frustrating for sure.
Yeah. Totally. Well, I could talk about this stuff all day long. I don't know if there's anything that you felt like we didn't cover that?
Wow, yeah, there's a lot. There's a lot that we didn't cover, but I don't know that we should try to get into it all now. We can certainly maybe have another discussion. I think that I don't want to discourage people from becoming property owners. Certainly, it can sound like, especially coming from a lawyer, it can sound like a minefield that who would want to embark upon this this foolhardy notion of owning a property in California today. But it's really just a matter of knowing what the rules are, and then being the best landlord you can be. And I certainly can tell you all the horror stories, but there are many good stories as well. That purchases and ownership that goes well for years, and never a problem arises. But certainly I do deal with the problems that do arise on a daily basis. So that's the bulk of my experience is dealing with landlords and their problems, and tenants and their problems. Sure. But I still think it's a great business to be in. If you're informed and ready for adventure,
Right. If there's a tenant or landlord out there that needs to get a hold of you, what's the best way to do so?
Yeah, so you can go to my website. It's petalumalawyer.net, or just call the office. You can find the phone number on the website. I'm in Petaluma here. We're in the office, Monday through Friday, 9 to 5. I'm usually available to see people pretty, sometimes there's issues that come up that need immediate attention. And I'm certainly usually available to see people on a somewhat quick turnaround basis. And if I can't help, there's wonderful attorneys here in the area that I can refer people out to as well.
Well, Pauline, thank you so much for joining us today. Yeah. This was a great podcast.
Yeah.
Really informative. This is a landmine trying to navigate this.
Yeah.
A landmine field trying to navigate.
Yeah.
So thank you so much for giving some insight that way. And I really encourage people to reach out to you when they have a tenant or landlord issue that way, because it's just too complex to navigate on your own that way.
It can be a full-time job.
Yeah.
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 So yeah.
Well, thank you everyone for listening. If you enjoyed this content, please hit like and subscribe so you can see future episodes. See you guys later.
See you next time.
Bye.
Welcome to the LivXplore Podcast. If you like what you hear, please hit like and subscribe.